tuned in to New Day live here on TV3, and it's now time for us to head into the chamber. Now, this morning we're taking a look at ADR, which is our alternative dispute resolution, and it's received attention and increased patronage from clients litigating civil cases all over the world. But how is this impacting on the services of lawyers as patrons seek out other means in resolving their disputes? 8,672 were settled through the ADR process from 2008 to 2013, and between 2008 and 2014, 34,701 cases were mediated, out of which 16,913, representing 49%, were settled. This represents 50% of the cases, and only 57 out of the 333 district and circuit courts in the country provide ADR services. Also, 188 out of 257 cases were settled through the ADR process from January to August this year alone, at all the 6 selected ADR courts across the region. Also, 215 mediators have been trained and assigned to all the 57 courts connected to the ADR services here in Ghana. And those are some statistics for you concerning the ADR process. Right, my guest this morning is Clara Bieri Kasati. She is a legal practitioner, and she will educate us some more on the ADR process. Good morning. It's good to see you, Clara.
Good morning, and I'm happy to be here.
Right. So, let's start off by just giving a bit of the background to the ADR process as a whole. What exactly is ADR? When we talk about alternative dispute resolution, what do we mean?
Okay. In Ghana, when we talk about ADR, we are talking basically about 3 mechanisms. Generally, it refers to other means of resolving disputes other than going to court. That is why it has the name alternative, because it is a mechanism for resolving disputes other than going to the court. In Ghana, there are 3 of them. We have negotiation, mediation, and arbitration.
Okay.
In other jurisdictions, arbitration is not considered an ADR mechanism, but in Ghana, it is one of the ADR mechanisms.
So these are the 3 main forms of, or other forms of dispute resolution?
Exactly.
Okay, so which one is most common here in Ghana? Which one do we tend to use most?
Mediation. Mediation is more used than the others, but generally for businesses, arbitration is also gaining grounds. Okay. The one that seems to be least used is negotiation, but the argument has been made that people will usually negotiate before they attempt any of the other, even before they go to court or attempt any of the other mechanisms for resolving disputes. If I may just explain the differences between the 3 of them.
Yes, please, go ahead.
Negotiation generally is the disputing parties talking between themselves without the assistance of any third party. They themselves sit face to face, they discuss the issue, and they see how they can find a common ground. That is what we refer to as negotiation. Now, mediation is an assisted negotiation. We call it an assisted negotiation because there's a third party, usually a neutral person. It is required that the person should be neutral and impartial. The person sits and then discusses the issues with the disputing parties and then helps them or assists them to find innovative ways of resolving the dispute that would be satisfactory to all sides.
Okay.
Arbitration is the one that is quite different from all of them. In arbitration, you have a third neutral and impartial party who makes a decision for the party. Mediation and negotiation, no third party makes a decision for the parties. But in arbitration, the arbitrator, who is a third party, will at the end of the day make an award to decide who wins the matter and who doesn't win the matter.
Okay, so who decides whether or not a particular matter should go for ADR? Is it the parties themselves or is it court ordered?
There are two kinds of ADR. There's a court-connected ADR and then the party-driven ADR. The court-connected ADR is a situation where the parties have already gone to court on the dispute, but the judge looks at the matter and the judge thinks it is reasonable for him or her to let the parties first try ADR, and then if they don't succeed, they can come back to court. Under our Courts Act, a judge has the power to look at a dispute and decide whether or not to refer the dispute to ADR. Okay. So there's a court-connected one, and then the other one where the parties by themselves, without going to court, choose to use ADR.
So is it mandatory for parties to use ADR, or is it by force, or can they refuse?
It's not by force. The entire thing is voluntary. The key rock to all the ADR mechanisms is that it should be voluntary. So the parties should be free to decide whether or not they want to use it. But usually when the parties become aware of the advantages of ADR, virtually always, they would opt to use the ADR because it has enormous benefits for dispute resolutions.
And what kind of disputes are usually submitted to ADR? Is it just civil cases, or criminal cases as well can go to ADR?
Generally civil cases. Criminal cases, the ones that can go to ADR are misdemeanors, the ones that are not very serious.
Otherwise,
such as? Maybe assault that is not aggravated, and then all other misdemeanors, they can go to ADR.
So crimes or offences that are not so serious?
Exactly, that are not so serious. But serious offences are not, you cannot use ADR for those ones. Those ones rest in the bosom of the state.
Okay, so give us some examples of some of the civil cases that would usually go to ADR.
For court-connected, usually family issues. Family issues, usually most judges would recommend ADR, or any other disputes where you can see that the disputing parties have a relationship. The reason is you try to preserve the relationship. In a court system, our system is adversarial. Everybody goes all out to win. And when you go all out to win, everything is at stake. At the end of the day, generally, for family members, you would have disrupted relationships. Parents would have been put against children, siblings against one another. But if they are sent to ADR, they are able to discuss the issues. Even sometimes, maybe what one party really needs is, I'm sorry.
Exactly.
That's all they need. I'm sorry.
So you don't need to go through the whole court process.
Exactly. And then when you have you sit with them, you realize that all the person really wants is, I'm sorry. The apology is rendered. The parties get together, and the dispute is better resolved. Their relationship can continue. But if they have to go to court, you can be sure that at the end of the day, it is very unlikely that they would still maintain
that cordial relationship.
Exactly.
Okay. Are decisions taken from ADR binding on the parties?
Yes, the decisions are binding on the parties.
So that means they are enforceable.
They are enforceable. Okay. If you reach a negotiated settlement, for example, we have what we call a negotiated settlement agreement. If you reach an agreement and then you put it in writing, and then the parties sign that agreement, it is binding.
So this is before the process begins. You both have to agree that whatever decision that comes out of the process will be binding on both parties.
Exactly. Once you agree to engage on the process, the expectation or what the law, there's a law governing ADR practice. We have the Alternative Dispute Resolution Act.
Okay.
So once you agree that you are going to resolve the dispute by ADR, if it is negotiation or mediation, at the end of the day, when you reach an agreement and then you sign that agreement, it is as valid as though it was a court judgment. You can just take that agreement to court, register it, and it will be enforced as if it is a court judgment. It has the same validity as a court judgment.
Okay. What is the role of these mediators, and what kind of training do they have? Are they taken through any kind of professional training to be able to mediate between parties when disputes arise?
Yes, there are professional mediators, but there is no requirement that they must be trained. The other flexibility about ADR is that parties can choose whoever they want to assist them resolve their dispute. So there's no requirement that the person must be trained. However, it is just like a profession. If you want to derive the maximum benefits from it, you should get somebody who is trained to deliver that service. The person would be able to help you achieve the outcomes that you want. So yes, there are certification bodies that train ADR practitioners, mediators, and then arbitrators. Some lawyers even go for the training as well, so that they are able to provide those services for their clients when it is necessary.
Okay, now I understand that only 57 out of the 333 district courts and circuit courts in the country practice ADR. Is that correct?
those are the statistics, but generally all the courts should be able to practice ADR. It's just that sometimes capacity. The issue is about capacity.
So are there plans to extend it to other courts?
There are. I know that there's an institution, there's the Ghana Association of Mediators and Arbitrators, GAGMA. They have plans to train as many as they can across all the regions of Ghana for people to be able to provide ADR services in their communities. ADR would be most effective if we are able to bring it down to the level of everybody, the ordinary person. So that in every community, if anybody needs ADR services, it should be available to them. We would have less acrimony in the society, and then there would also be less pressure on the courts. Right. Because right now there's a lot of pressure on the courts, and then the filing fees are rising. So I think if you look at the economy and the way the society is going, we need to take ADR seriously. If we do take ADR seriously, it should be able to benefit the society as a whole.
Right. Now, less pressure on the courts, but what about the services of lawyers? How does ADR impact on the services of lawyers? Will it not kind of phase out lawyers? Lawyers will be out of jobs?
Not at all. Because as a good lawyer, what you really want is what is in the interest of your client. I'm going to court from here. There are several delays associated with the court processes. If you are mediating the process, you agree with the other lawyer or with all your clients, you meet a few meetings, and most likely that case is done. You will still be able to collect your fees.
Okay, so lawyers are still involved in the process?
Yes, lawyers are still involved in the process, because even negotiation, you can decide to use somebody who you think is good at negotiating to negotiate a good deal for you. So lawyers are still involved as well, but it doesn't have to be a lawyer.
Okay, so in your view, would you say that ADR has helped to decongest the courts to an extent?
To an extent, yes, but there's more work to be done. There's a lot more work to be done.
Okay.
I think a lot more sensitization has to go down, because a lot, talking with some clients, they are usually worried as to whether or not the agreement that they have got outside the court is binding. But it is. If it is complied, there are certain procedures to comply with. For example, it has to be signed by all the parties. Once that is done, there's a procedure to register it, and it is very binding for the parties without the associated cost and stress and adversity of going to court.
Okay, but what if a party is not happy with the process or the procedure? What happens?
The party can withdraw at any time. Okay. It is voluntary. It is absolutely voluntary.
Until the time where a decision is made, or even after a decision is made?
After a decision is made, you cannot.
Because then it's binding.
It's binding. Once a decision is made, it's binding. But before a decision is made, a party is free to leave. The only exception is with arbitration.
Right.
Once you commit to arbitration, the arbitrator, you cannot dismiss the arbitrator without due reason. So in a situation like that, unless both parties agree to withdraw, one party cannot withdraw. But with mediation and negotiation, any of the parties can decide at any time to withdraw if they think they no longer want to proceed. It's absolutely voluntary.
Okay, so what about concerns that a mediator or an arbitrator may be biased to a certain party?
Okay.
Does it happen, or is it possible?
It's possible, but unlikely. Unlikely in the sense that when that happens, any of the party who feels that the mediator is biased can raise the issue of bias, and you can actually ask the mediator to step aside. Same with an arbitrator. So if an issue of bias arises, you have the option, you have the power to let that person go, and then get another person who you believe is neutral and impartial. Okay, so finally, what is the future of ADR in Ghana? If you look at global trends, it should be huge, because if you look everywhere globally, ADR has become the norm. Even if you look at our dispute with Ivory Coast, they are using arbitration. They are not using any other litigations. Everywhere for the world, especially for businesses, for individuals, they have come to realize the immense benefits of ADR, and a lot of people would opt it. So the future of ADR, we expect that once a lot more people are trained to provide the service, it should augur well for our society. Okay. Right. Thank you so much for your time this morning. Clara Bieri Kasati is a legal practitioner, and she joined me in the chamber this morning to talk about the benefits of ADR, alternative dispute resolution. Thank you so much for your time once again.